Hey everybody, Chuck Cook still in Atlanta, Jesse Bliss at a mountain lodge in Colorado.
Yeah. I wish.
That's like, I love the piano, by the way. It's very. Can you play?
I can walk back and just play a jingle if you want, but I won't.
I know a hymn or two I play with one finger. My wife is actually taking piano lessons right now. She's trying to relearn what she learned as a 7-year-old. And I told her, I threatened her. I said, if you do that, I'm going to have to re-pick up the instrument that I was taught as a child until I was 8 years old. I'm not sure she's a big fan of the accordion.
Wow.
You know, when you come from German immigrant stock like I do, that's the instrument you're taught when you're a kid.
Mm-hmm.
Beer barrel polka, you know, there's no beer in heaven. That's why we drink it here. I know all of them. So, Jess, today, I want to talk about the first thing to talk about is our Guevara case, which is the 601A case. Mm-hmm. And we have lots of folks that tune in right away to talk about this. So, government filed a motion to dismiss. We filed an extraordinary reply. The government on the 28th of April, so about 12 days ago or so, filed their reply. We requested oral argument. The government requested oral argument. There's no argument date set. There's no decision yet. Your take. Where are we?
Well, I hate to speculate, but I mean, I would assume
that's what we do here at the
IMMPact. I would assume that Judge Lynn is weighing what to do and whether argument is necessary for her to decide. I mean, just because you request it doesn't mean you get it. I mean, it could be that she doesn't feel it's appropriate and is writing a decision. She is, in my experience, been very timely with motions practice. That's what we call it, motions practice. So we just have to kind of wait and see. I mean, in the meantime, we are exchanging what we call, joint status report that we have to file with the court, which is going to basically dictate how we proceed as if the case is going to continue for discovery and everything else. And so we're still moving in the background with the government and exchanging our proposed plans on how to litigate this case. I mean, it's a giant case. And so I think a lot of the comments, I'm not looking at them now, but I'm sure they're going to be like, what's happening? Why are we doing this? Why are they adjudicating some more recent ones? I mean, I don't know if it's a mole or a friend or whatever you call it, but, we've learned not only from the community, but from other people who've helped us that they are adjudicating cases out of order. And I think our team is exchanging ideas on how best to present that evidence to the court. So it seems like nothing's going on, and at the same time, a lot's going on. And I can't overstate how complex some of these issues are. I mean, I know we feel strongly that we're right, but the government, just broadly in all the cases we'll talk about today, has really doubled down on its position that it really has the ability to do whatever it wants,
whenever it wants, and
whenever it wants, if at all. And so, it's I hate to use war terminology, but they've really taken a really hard position that they don't have to do anything for for immigrant petitions or benefits or whatever,
which is shocking. Now, I monitor the listserv, not the listserv, but the Facebook page, and it seems like, and Greg's not here today. I actually know neither of us know where Greg is. So, Aaron's not available, but nobody knows where Greg is. He could be on a plane. He's been speaking a lot recently, but we know that many of our plaintiffs had their cases transferred 2 or 3 times in the last week, like ping pong balls, going to different service centers, which is insane. Honestly, it's insane. Yeah. We also know, because they said this in their reply brief, that they have hundreds of people now assigned to HARP, supposedly working on cases. And we have reports from all of you, which we're very grateful for, about the out of order cases. We have, by the way, have also discovered many more than what you have. We've discovered hundreds more than you have. And it's just a question of how we're going to get that to the judge. I would hope we can get to that to the judge this week, Jesse, because I think it's really important as she's considering the idea to let her know there are facts out there that we have obtained through digging through piles of dirt, kind of like opening up the garbage of a suspect and finding something in their garbage can that implicates them, that the court needs to be aware of, that goes directly against what the government is alleging in their filings. And that's material to the court, and we're going to get that in, but it has to be done the right way, because nobody likes a snitch, and it is, you just have to do it the right way. And that's what we're coming up with. I would hope we have that ready to go by the end of this week. But there's also the class certification pending. And I will tell you, Jesse, one of our clients, we filed like 2 months ago, well, not even, just a little under 2 months ago, they filed their own 601A mandamus because they wanted to do it on their own. And the government lawyer here, they filed it in Atlanta. And the Atlanta U.S. attorney said, hey, would you hold this case in abeyance until Guevara is done?
Yeah, I've heard that actually, and other people have contacted me and said that that's the position. So it's a well-known, national case. It's what we wanted.
It's affecting everything. And clearly the U.S. attorneys are being told, this is a big deal. This is important. Don't what's afraid of is going forward in a place like Atlanta, you get a sympathetic judge, and they order them to do it. Now all of a sudden the orders start pouring in to do them out of order. And they're stuck between a rock and a hard place. So they're trying to get one consistent decision. We're trying to get the other consistent decision.
Yeah. Well, I also think, we know they're not going in order.
Yeah.
I don't know why they wouldn't have an obligation to go back to the court and disclose that, oops, I know we said we follow this processing rule, but we really don't. I don't know. Again.
Well, the reality is in the same district, I'm going to switch over to a different topic because it's really kind of the same thing. In the same district court, no, in different district court, so this is in Washington, but in the same circuit, we have another judge in our EB5 litigation where this basic same issue is at stake for EB5 people, which is you're not taking cases in order. You're not following the visa bulletin availability. You're lying to the court. And in that case, using the same method, we were able to show the judge when the government wanted no discovery that no, judge, they need to tell us they're not following the visa availability / priority date rule. They're not. And the judge granted our part of our motion for discovery, which Jesse, I don't think this happened before in an EB5 litigation. Are you aware of any?
No, again, I think, I told you my position over email. I do think it's a monumental victory. I applaud you guys. I'm not involved in that case. I think that your team did a hell of a job at convincing the judge that, that you can't just take the government's statements at face value. They don't take our statements at face value of our clients. Why should we have two different sets of rules? And I think we called them on it. There are important facts that need to be discovered. And, the government likes to have it both ways. They'll say, well, there's no record, so we can't lodge a record, but there's no discovery either. And they just don't want to disclose the facts. And luckily,
what's interesting about this EB5 case is they have taken the position that they have the rule of reason, which I know is Jesse's favorite reference point, the rule of reason, which basically is if they're doing something reasonable, it's okay. The judge is not going to look behind a reasonable government approach until Gorsuch gets rid of Chevron. We're not going to look behind that. And they said, look, we look at all these cases and we take them using a two-pronged approach. One, the day it was filed. We do cases in the order that are filed, but on top of that, we overlay visa availability to make sure that numbers aren't being wasted. Now, I don't know, 10,000 EB5 numbers have been wasted, Jesse, over the last couple of years.
Yeah.
Maybe more, because they're not following that rule. So they're telling the court one thing, and we were able to discover at least 590 cases. Now, this is not where there's 130,000 cases. I mean,
Yeah.
like 15,000, 30,000, 20,000 cases. They took 500 out of order after our last plaintiff's filing. And that would be fine. I actually wouldn't have a problem with that, Jesse, if they were saying, you know what, if you're not from India or China, which have backlogs, we're going to take you out of order, because that is their rule of reason.
Yeah.
That is their rule of reason. So what the judge ordered, and this is I think dynamically awesome. Now she's not going to let me depose the head of the IIO. I don't get to bring Erdshadu in and sit her down and question her. But I get this: the number of unadjudicated 526s by country of birth of the principal, and the earliest priority date of each of the country's oldest pending 526s, and the number of 526s reached by quarter assigned by country of birth of the principal applicant. Now, and which have been adjudicated were expedited. Now, this from 2018 to the present, for the last 5 years. Why is that important? Because if you're not from India or China, you should have been adjudicated 4 years ago.
You'd think so. Yeah. I mean, I'm going to go argue a case in 2 days.
I know you are, and you're going to use this argument. Judge, in the Northern District of California,
yeah,
I thought through the mists of darkness.
Yeah, I thought about doing that. I think, we're in a different posture, and, I don't want to, I'll mention it maybe during the argument, but I don't want to, the DC circuit can be a bit difficult about.
Who was your panel?
I haven't looked at it yet. I should look at it today. I should pre-release.
I'm curious. Maybe you'll have Henderson again.
Let's hope not. And my clients were not Chinese or Indian nationals. They were from Australia. And then what's crazy in that case, I mean, just to talk quickly about what's happening is the judge not only said, okay, well, there's a rule of reason and they're following it. So although the delays are harming your plaintiffs, I'm going to dismiss and kind of resolved facts in favor of the government on a motion to dismiss posture, which me
is inappropriate.
Totally. And it's,
by the way, who's the district court judge?
It's Chief Judge Boasberg, who's usually fairly good. I mean, I think he tried to be a little too cheeky. You mentioned like Field of Dreams about the EB5 process, about how, if you build
he was the same thing in the K1 cases. He loves popular culture.
That's cool. I know he's a former basketball player from Yale, I think.
Yeah.
All good, but I mean, I think what we're doing here is, again, it's very similar to our case on the 601As, where you have the government saying things to convince judges to throw cases away, and the reality is that what they're saying is not entirely true and accurate. Yep. And judges should be cognizant that at the pleading stage where we're at in the 601As and you on summary judgment, like, hey, it's not appropriate. If there are really factual disputes, you can't just take the government's word for it.
No, absolutely not. You can't. Yeah. You can't.
No.
On the 601 litigation, if you are still interested in pursuing that, we have filed a case. We're still adding plaintiffs to that case, and it's great. It's already filed. We just have to amend our complaint. So if you're interested, you just go to IMMPactLitigation.com and you will be able to, here we go, IMMPactLitigation.com, 2 M's, and sign up. We'd love to join you in that case. We've got a bunch of plaintiffs ready. We'd love to add you. And the last thing I wanted to cover today, Jesse, is we are refiling our United for UK Recovery of Fees case. And if you are Ukrainian or know Ukrainians who got ripped off by the government, have them come to our website. We'll be happy to help them. All right, Jess, we got some questions here today. Sonia is saying good morning. She's always here. Good to see you. Good morning. Hell, is any good news of 601 complaint? Yeah, it's filed, Daniel. An email was supposed to have gone out, Jesse. I know I asked Greg to send an email out to everybody with a copy of the complaint, and I thought that was done. Daniel, if you want to check your junk mail to see if something's in there, but that has been filed. The Clorox, I appreciate the use of colorful language. I myself have used such colorful language in my life. But the DC Circuit Court, they're just sitting on it. Jess, if in your argument, why don't you just ask about that? Just ask the court.
Right.
Hey, Judge, have any of you talked to Judge Henderson about? No, Jesse's not going to ask the court about that. Maybe knock on her door. I mean, you're right on the same floor. You can just knock the door and say,
Yeah.
What can I do to help? Kiara, the government's also frustrated because they filed something not that long ago about completely irrelevant stuff, but they want a decision as well. Good morning. What happened to HR601 AB transfer back to Nebraska? Well, Kiara, that's the thing. There is no physical location for HART. It doesn't exist. So what they said was this virtual service center employs these examiners, but they have to live within 4 hours of the service center. Well, the unemployment rate in Northern Virginia around the Potomac Service Center is like, 1%. And the unemployment rate around the Nebraska Service Center is probably 2%. So they probably sent it back there because they have somebody local that could go over and drive it to their house without stopping to pee for 4 hours. That's apparently the rule, Jess. I mean, that's the rule. You can't stop. As Greg noted, it's probably because somebody got in an accident several years ago and all the files are strewn all over the freeway or something. And there is no HART service center in the drop-down menu. Heaven forbid they should do that. Jess, we're going to be seeing June 23rd, 24th, 25th, and 26th is the annual conference of the American Immigration Lawyers Association. And do you know who will be there at a kind of an open forum Q&A? Do you know who that's going to be?
No.
I think Miss Chadu is going to be there again.
No way. Really?
No, maybe she's going to apologize for lying to us last year. Not really quite sure.
Yeah.
But she's supposed to be there, and that will be a unique opportunity to find out what the hell is going on with HART. Okay, and I keep calling it HART.
Yeah.
All right. Go. We talked about. We don't have anything. 61A sent back to Nebraska. Says faster process, which must mean fast processing. Well, we'll see. Obviously, they one thing that's not in their reply brief, Jesse. Hey, Judge, we've adjudicated 100 of these 300 cases.
Yeah, I mean, we know that they actually have adjudicated them. It's unfortunately they're doing them last in, first out, and not first.
Not 2020, right?
Yeah.
All right, Brittany, 61A group, the wording of our transfer is different this time. Last week transferred fast process. February didn't say that. Well, yeah, they do change it occasionally. There's some minion that types, the use this verbiage today. Put in the word faster processing so they don't sue us again. I actually never read most of that junk because it's just boilerplate garbage. But they love to give false hope to people.
I'll say this. I mean, I just think it's a missed opportunity for the parties. I mean, one of the benefits of litigation is the ability to have a direct line of communication so you can negotiate if you see to right a wrong, because we have a wrong and they're not. I'm actually, disappointed. I guess I shouldn't be anymore, but
see,
this
Jeff,
obviously,
when you were there for 15 years,
yeah.
Also, one of the first things you do is talk to opposing counsel. What do we need? What needs to get done?
Yeah. Well, I think the problem is, the DOJ, attorneys, they have a client just like we have clients. And I think they have to, like we do, if the client wants to, they're supposed to control the show. And so it's not the DOJ attorneys that are, in my view, are ever to hold blame. I mean, they have to litigate the case the best way they can for their client. And if that means filing a motion to dismiss, fine. And they also, have to trust the information they're being provided by the client. So here, it's not, when we talk about big, the government, it's really the Department of Justice has to represent USCIS. It's USCIS is telling them, hey, this is the way we do business and it's actually appropriate. Go defend it. And I think if you gave the Department of Justice truth serum, they would tell you this is not the best case.
Let me ask you an inside baseball question.
Sure.
You're working for you're the U.S. You're with oil. You're with DOJ.
Yeah.
First thing you do when you get served is you call your client, right? And you say,
100%.
What's going on? Tell me the story.
Yeah.
And then you make a litigation choice about how you're going to litigate a case based upon your client's instructions.
Yeah, exactly.
But at some point, as a lawyer who's going to be back in this court 100 times in your career, who opposing you on this case, somebody you may see again in the near future many, many times. Mm-hmm. You also want to maintain a relationship with that individual because relationships are what help lawsuits move in an easier fashion to conclusion.
Yeah.
So you call, hey, here's our situation. You don't disclose client confidences, but you say, you know, what's your ask, attorney, for the plaintiff? What's your ask here? What do you need? I read your complaint. What do you need? And you go back to your client, say, here's what they need. What do you want to do?
Yeah.
And they tell you, we're not doing it. Fight.
Yeah. Well, I think too, I mean, so one of the things, I don't know if this conversation has happened, but one of the things you may do is say, listen, you know, we can do this for you and you understand you want to fight, but let's say we lose in the class. If we lose a motion to dismiss and the class is certified, you know, we're going to have to revisit this conversation, because not only are you going to may get a really bad decision that everyone's going to cite and cause further litigation
on everything, on everything.
Maybe, you know, but potentially we're going to be facing attorney's fees that you, USCIS, are responsible for paying, not us, DOJ.
Yeah, we're not paying anything.
And you know, we've seen this happen before, and so I think the marching orders may be that, hey, try to get it dismissed. If you can't, let's revisit. But to me, and again, I think at DOJ, I'm not saying I can handle the case any better, because you're probably going to be told, if you're the attorney's actually doing the work, what to do. But in my view, again, I can understand they want to trot out the Patel decision as its brand new toy in a lot of things. But to me, what is tough to get around, you know, and take COVID and take everything. What's really tough for me to sit is families who are out of work because of the delays that have gone from 4.6 months or so to 30. What?
No, it just went up, by the way. The number
did it?
Again,
but that's not a good fact. I mean, that's just, and it's not, you can't explain it away by COVID. Like if I had something to do, especially in 2023.
Yeah, Nebraska, by the way, now 38 months.
Yeah. So like if I were 2 years late for something and I went to my client and said, oh, well, we had this COVID and I didn't get to your case for 2 years, I'd get fired.
No. Well, by the way, Potomac is 43 and a half months now coming up on 4 years.
I don't understand. I mean, again, judges can do whatever they want. It's just really tough for me to take.
Well, this is something I think we should include in a follow-up piece of information for the court publicly.
Yeah, I hear you.
All right. So Shaylee, I've been lying to the court. Yes, that is absolutely what they're doing. When does the judge have to make a decision? Well, again, there is no deadline for judges anywhere to make a decision within a set period of time. Ask the plaintiffs. But this judge, our own experiences with her is that she's relatively quick.
Yeah, she's not going to sit on it.
She's not going to sit on this. This is not going to be 6 months. This is not like our litigation on the H-1B where the judge sat on it for 3 months.
Etta Cooney, so there was a case that Judge Lynn decided that I worked on that was actually quite favorable. But Judge Lynn, who was appointed to the bench fairly recently, was actually took that case from another judge who did sit on it for like a year. Very similar case. And when she got it, she wrapped it up. I mean, and she actually held a status conference to get her head around the issues. And she was very serious and honest about what she wanted to do, which was resolve the case that had been, in her view, sitting for too long. So she is brilliant. I mean, there's no. I mean, I'm not going to change my mind if the case isn't favorable for us. I mean, she is. Brilliant. She knows what she's doing. She's
the kind of person you want on the bench.
Totally.
All right. Let's see. You want to email Greg@visalaw.com. Greg@visalaw.com. That's what you send your emails to. Galilei is drunk of waiting. I think the word is tired, but okay. Do you plan on suing H-1B lottery abuse? Well, first of all, we have to have a plaintiff, and we'd have to show actual harm. So, and the plaintiffs really are companies. Yeah. They're not necessarily foreign nationals. You know, the answer is we're thinking about it. We have to have a legal theory that's going to work this time. I don't have that yet. Everything, you're welcome. Evo, I'm being transferred back to Nebraska. Now I get to fill out processing time. Yeah, keep submitting it. You should submit 1 million out of processing time requests. Inundate the out of processing time department. squeaky wheels and all that. And that was field besides any good news, what she would expect. Filed. Oh, it takes 60 days for the government to file a response. So.
Yeah. I mean, I think you have to understand that if they're going to fight on the 601As, you'd expect the same fight. I mean, they're not going to take inconsistent positions.
No, they're not. So they're going to fight, and we'll go for it. Natine, I emailed you. I know you got an email because I emailed you directly and told you exactly what the timeline was. The government has told me that November 2019 cases should be adjudicated by year end, regardless of what happens in our lawsuit. That's what they said. Now, I don't believe them, but that's quite possible. But I would expect to have a decision on our case before that. We will be submitting. I think we have oral argument set for August in that case, and that judge is right on top of stuff. So,
yeah, she's sharp too. Yeah.
Next steps to follow. We are filing as we noted earlier, we're filing a joint notice of what is it called again?
Joint status report.
Status report about when we want discovery, when discovery is going to be complete, when
our issues. Yeah.
That stuff.
It's really like the syllabus for the entire case.
Yeah.
I don't know. So like if you ever went to like a class, it's just going to map a roadmap for how the case is going to go.
Liz, thank you for allowing us to help you. That's my thank you, because we really want this to make a difference. And the team, thank you. And I love fighting for those EB5 cases because I'm really pissed off about that because we caught them with their hand in the cookie jar.
I think, yeah, again, there's something really wrong about how there's certain programs. I think Greg made this point before where it's a policy decision that they don't, for whatever reason.
They hate the EB5 program. They just hate it.
Well, it's the same thing with U visas, right? Yeah, I mean, and they have a cap and I get it, but they really don't do much to help those waiting.
Jesse, let me ask you about U visas because I've done litigation on this, as have I. So Biden comes in, they announce, hey, dude, we're going to stop adjudicating U's and just do all the deferred action for everybody. All right? And they start doing that for 10% of the people, and then they stop. And then they went back to adjudicating cases again. Do you have any idea what happened?
I mean, I don't know if it's related to the bona fide determination process.
Yeah, the bona fide D, but they're not doing that BFDs.
I know, but you know why? Because I think the whole point of them was to streamline the process and bend the processing times down so people can start working. And maybe they determined that there was no easy way to do it, and so they just abandoned it. And so they still have that. They
didn't say anything. They made a big announcement about BFD.
Oh, totally. They held a parade for it. I mean,
like the balloons and everything, and then
exactly.
And everybody got up, and one person in the community gets their EAD. Tia Maria, she got her EAD. Yeah, well.
Yeah, it's
sorry.
I think they really need to go to a system where we, as a community in the United States, allow people to work upon filing. I don't understand.
Back in the day, Jesse, back before you were practicing law, that's what asylum was.
Oh, yeah. No, I know.
And the Congress changed that because there was a ton of fraudulent asylum applications. But now they say you have to wait 6 months. And what do we have? A ton of fraudulent asylum applications.
Yeah. Well, I think, too, I'm not this, again, I'm not crazy. I don't pretend fraud applications exist. Of course they do. And that's what causes part of the problems because one bad apple can ruin the bunch. But, I think I'm all for, and, again, you can hate me on whatever social media you can find me on.
Jesse.
But I mean, I'm all for kind of the Immigration Reform and Control Act policies where we had very, very hard consequences, but very favorable benefits because we trusted that by and large, people would do the right thing. And in a society, of course, everyone's not going to do the right thing, but we trust them first and verify.
Yeah.
And again, we can crack down on immigration attorneys and those in the field like notarios who don't do the right thing and file frivolous applications. But depriving people who are here and we know they're here from working is mindless.
Especially when you have a massive employment problem.
Yeah.
You have 5 million open jobs.
And what it allows for, and what people have never understood is people are still going to work. It's just that they're going to be trafficked by mostly US based employers who are going to hire 10-year-olds and 11-year-olds and women and know that they don't have status and traffic them, labor traffic them. And that is a huge issue that, I mean, again, we don't really have anyone in Congress, but I mean, if we did, like, that is the issue. Everyone wants to talk about headlines and that, but like, we have a massive trafficking issue, labor trafficking.
Sure we do.
I mean, it's just
well, they're
insane.
all going to get T visas now, right? They're going to get a couple last questions, then we'll be done. If you're referring to the native Peruvian artwork behind me, that's actually done by a street artist. If you're referring to Yoda, I'm not sure who did that. My daughter gave that to me. Professor Yoda in the background. Despite Nebraska claiming they don't let you submit an inquiry 43 because Potomac's at 43 months, right? So they take the longest. It's really just a disaster. The whole thing's a disaster. All right, Jess, been a great week. Hopefully we'll see Aaron and Greg next week. I'll be live tomorrow at 1 o'clock. Last week I forgot because I had a big meeting and I got out of late up and I couldn't get on, but I will be live tomorrow at 1 o'clock. Till then, you guys have a great week. Jesse, always a pleasure to see you.